Good morning, everyone, and welcome to this meeting of the Licensing Subcommittee here in Christchurch. Item 1 on the agenda this morning, election of chairman. Can I seek nominations for the election of chairman, please, members?
I'd like to nominate Councillor Flagg.
I'll second that.
Thank you, members. Item 2 on the agenda this morning, apologies. To receive any apologies for absence. I think we're all here. Thank you. And item 3, declarations of interest, members. Councillor Barron.
Thanks, Chair. Only that the bar's in my ward, so it's a bar that I'm familiar with. I do know it, but I don't know the licence holders at all, and I haven't been contacted by anyone regarding this prior to today.
Thank you, Councillor. Right, if I may just run through the proceeding for this morning's meeting. First of all, can I just ask the clerk to deal with any matters of general housekeeping for everyone before we... Thank you.
Thank you, Chairman. Just general housekeeping notice. Please note that this meeting of the Licensing Subcommittee is being audio recorded by the Council. And please could I remind everyone, therefore, to use their microphones when speaking, and the way to do that is to just press the silver button and the red light will appear. Please note that this meeting room is fitted with an induction loop for the benefit of hearing aid users. Hearing aids should be switched to the T setting. There are no scheduled fire alarm tests, so if the fire alarm should constantly ring, please follow officers out of the building by way of the nearest available signed fire exit. If you should need any specialist assistance, please let a member of staff know. Toilets are located outside of the room and along the corridor. Please can I ask that mobile phones be turned off or at least switched to silent for the duration of the meeting. Thank you. I will now pass back to the Chair for the next item on the agenda.
Thank you. My next point is just to identify all those persons wishing to speak this morning, but now I have been given a list for item 5, so I'll be happy to deal with that when we actually come to item 5. So can I ask if there's any persons who are aware of people not speaking on item 4 this morning at all?
Good morning, sir, members of the committee. So my name's Sandra Graham. I'm the solicitor representing Camden Bar on the review application this morning. I do have to my right members of Camden's limited company, which is Lauren, who sits next to me, and Phil Curley next to her. And beyond that, sir, at the extremity of this row is Mr. Ian MacArthur, who is an acoustician with Clark Saunders Acoustics, and he is present to give any expert evidence, if that's needed, in respect of noise measures and noise reports. But, sir, perhaps I should say at the outset, it is obviously the Environmental Health Officer, Mr. Barlow's, application this morning, but I do beg your pardon, Mr. Barker. But I'm hoping that we can limit the issues such that perhaps no evidence needs to be called from the people sitting next to me, but we're entirely in your hands in that respect.
Thank you.
Thank you, sir.
So if I can just run through the proceedings then. The licensing officer or other council officer will present the report. The applicant will make their application. Questions of the applicant by all parties. Members of the committee, subcommittee will go first. Responsible authorities and other persons will make their representations. Questions of the responsible authorities and other persons, members of the committee, once again the subcommittee, to go first. All parties will be given the opportunity to sum up, with the party who spoke last to go first. The subcommittee will deliberate in private with the legal advisor and clerk present. Councillors new to the licensing may observe but will not take part in decision making. We have no other councillors observing this morning. The subcommittee will return and the Chair will announce the decision of the appropriate and written decision notice will be issued following the hearing in accordance with the regulations. And finally, the legal advisor will advise parties of any right of appeal as appropriate. Can I just ask that everyone's in agreement with that procedure? Thank you. Okay, in which case then, can I just ask officers to introduce themselves, please?
Thank you, Chairman. I'm Joseph Tyler from Democratic Services of BCP Council, and I'm the clerk for the meeting today.
Hello, I'm Mary Almeida. I'm a lawyer for BCP Council and I'm training today.
I'm Joanne McNamara. I'm a lawyer at Bournemouth and Christchurch Pool Council and I'm legal advisor to the subcommittee today.
Thank you very much. Right, moving on then to agenda item 4, a review of a premises licence, Camden Bar Kitchen, 4-6 Bournemouth Road, Poole. An application has been received by the Environmental Health for review of the premises licence for the premises known as Camden Bar and Kitchen, 4-6 Bournemouth Road, Poole. This matter is brought to the Licensing Committee for determination. Can I ask the officer to introduce the item, please?
Thank you, Chair. The background to this is that the Licensing Act 2003 enables the Licensing Committee to consider applications for review of premises licences or club premises certificates from responsible authorities or other persons and have regards to any relevant representations received. The Licensing Act 2003 gives the Licensing Committee the power to take such steps, if any, as it considers necessary for the promotion of the licensing objectives. The steps are to modify the conditions of a licence by altering, omitting or adding conditions, excluding a licensable activity from the scope of the licence, remove the designated premises supervisor from the licence, suspend the licence for a period not exceeding 3 months, or revoke the licence. Should the Licensing Committee take such steps as to modify the conditions or exclude a licensable activity, the Licensing Act 2003 allows for such actions to have effect for a temporary period not exceeding 3 months. The Live Music Act 2012 amended the Licensing Act 2003 by deregulating the performance of live and recorded music on premises. Licence for the sale of alcohol on the premises and between the hours of 0800 hours and 2300 hours, and if the music is amplified in the presence of an audience of no more than 500 people. If these criteria are met, then live and recorded music ceases to be regulated entertainment, and any existing conditions relating to live and recorded music are suspended. This also allows premises without live and recorded music on the licence to have live and recorded music. When the licensing objectives are not met, the review can be called, and Section 177A allows for the modification of the conditions of the premises licence to add a statement that Section 177A2 of the Licensing Act 2003 does not apply, so as to ensure all existing conditions relating to live and recorded music continue to apply, and conditions can be added relating to music as if A, the live and recorded music were regulated entertainment, and B, the licence or certificates licensed the live and recorded music. Any new conditions relating to music that may be added as a result of the review will continue to apply in accordance with Section 177A4 of the Licensing Act 2003. Camden and Kitchen is located at 4-6 Bournemouth Road, Poole, and a location map was attached as Appendix 1. Environmental Health has submitted a review following a number of visits to the premises due to complaints of noise nuisance from music. The application for review relates to the prevention of public nuisance licensing objective. The application is attached as Appendix 2. The current premises licence is attached as Appendix 3, and the consultation has been carried out in accordance with the Licensing Act 2003. One letter of representation from a responsible authority, planning, has been received, and the letter of representation is attached as Appendix 4. Further to the submission of this report, both parties have agreed to a condition to resolve the problem, and a copy of this condition has been provided to the committee and the legal advisor. So following the outcome of the committee hearing, All parties to the application have the right to appeal to a magistrates' court within a period of 21 days, beginning with the day on which the appellant was notified by the licensing authority of the decision appealed against. The determination of the application for review will not have effect until the end of the period given for appealing against the decision, or, if the decision is appealed against, until the appeal is disposed of. And that is the report, Chair.
Thank you very much. Can I ask the applicant, please, to beg pardon?
Yeah.
Okay. Good morning, Chairman. My name is Paul Barker. I'm an Environmental Health Officer with the Council. I work primarily in the out-of-hours team dealing with noise nuisance. We initially started receiving complaints of excessive loud music emanating from Camden in June 2019. Subsequent complaints have carried on since then, and we found that the premises were using the permission granted by the Live Music Act to have entertainment on an evening. Investigations then proved that the building wasn't suitable to contain that level of music and entertainment, and as such we discussed it with the premises bar, looked for a way forward, and we decided that a noise limiter would be the best way to deal with it. However, to make this enforceable, we need to come before the committee to attach a statement disapplying 177 so that a condition enforcing the use of a noise limiter comes into place, which is why we're here before you today.
Thank you very much. Could I then ask the applicant to address the committee, please?
Indeed, sir. I'll try and limit issues to the specific issues raised by Mr. Barker in his review application. But if I could just historically put in a nutshell how we've come to this particular point. The applicants took over the premises around 2010 and have operated since that time. And indeed, when they did take over, they took advice and had a report from the firm with Mr. Ian MacArthur sitting here on noise issues, so that they are aware of these. But unfortunately, just after or during the time that these complaints arose, there was unfortunately some mishaps within the operation of the company, in that there are always been 3 partners operating the business, an additional gentleman who left in April of this year, and his departure coincided with Lauren Nolan here being on maternity leave, and during that period, which is probably only about 3 months long, we relied perhaps too much on the management of the premises, who were there on a temporary basis. And as soon as these noise complaints came to our knowledge, then Mr. Curley, who predominantly prior to his partner, business partner leaving, predominantly operated other premises, as soon as these complaints came to Mr. Curley's knowledge, the acoustic expert was instructed again and looked at matters at the premises, indeed with the help of Mr. Barker from Environmental Health, as a result of which 3 issues were identified to deal with the noise complaints, which all came from 1 flat above the premises, flat 2B. 3 separate matters were highlighted as issues that could rectify the complaints from above. One was complaints from a hand dryer in the gents' toilets, which apparently the noise of the hand dryer was travelling up the wall of the building internally and affecting noise in one particular bedroom of the flat above. The hand dryer was completely disconnected immediately, and paper towels were now used instead. The second highlighted matter was that one of the speakers was on a wall that was sensitive to noise transmission through the buildings. That speaker has since been moved and relocated in a position where it does not cause any nuisance any longer. And the third issue was music noise that was being played within the premises. And in that respect, an agreed noise limiter was installed. It has already been installed, and it has been at the current time set to a level that is acceptable in the view of our acoustic expert. Unfortunately, the complainant in the flat above has not responded to any emails from my clients, and indeed I believe from Mr. Barker, to let us into that flat to know that the absolute levels are satisfactory to him, but save us to say that since this work has been done, I understand from Mr. Barker he's received no further noise complaints. So, sir, that's where we're at the moment. And indeed, the acoustic expert was instructed on the 9th of October of this year to look at matters. In fact, instructed before then because his report was the 9th of October, which is almost a month before the review. So I'm hoping that you'll accept that my clients have actively dealt with this issue as soon as they became aware of it. As a consequence, as Mr. Barker has said, we have come to an agreed condition that is acceptable to all parties to be placed on the licence if you see fit to deal with it in that way. So if you wish to enter into further discussion or explanation of matters, I'm happy to give it, but otherwise all parties are happy with the condition proposed.
Thank you, Ms. Graham. Do members have any questions at all? No. I think in view of the statement that we've been given this morning, I'd be happy to retire with the committee to come to our decision and come back to you with that decision as soon as possible. Thank you.
Thank you, sir.
Ladies and gentlemen, having considered the suggestions made this morning and the proposed variation is agreed between the parties, and having regard to the statement of licensing policy, the committee has decided to vary the licence to include the terms as agreed. And just for the record, I will read out the terms as agreed. The Live Music Act 2012 exemption, section 177 of the Licensing Act 2003, shall be disapplied to the extent that any live or recorded music, as permitted under the Live Music Act 2012, shall only be played through an in-house system that is controlled by a noise-limiting system. This noise-limiting system must have the levels set and maintained at levels which shall be agreed by officers of the BCP Council, Environmental Health Department. Thank you very much.
If I just explain that there's a right of appeal against any decision by the subcommittee, and that period starts 21 days beginning with the day in which the notice of the decision is given in writing.
Thank you, sir. Good morning.
Good morning, everyone. Welcome to this meeting of the BCP Licensing Subcommittee. I'm Councillor Flagg, elected chairman for this morning's meeting, and I'm joined by Councillor Barron and Councillor Burton. Can I just, first of all, confirm I've been given a list of representatives wishing to speak this morning, and I wondered if those people present could just identify themselves, please. I'm fully aware that Councillor Beasley is sat at the table. I've also got Mr. Burton Smith. Thank you. is it Mr. Charles Guntor, is it? Not speaking. Right, thank you. Mr. Stephen Nichols.
Yes, sir.
Thank you. Mr. Patelvici, is it? Patelevich. Thank you. And Mr. Isherwood.
I'm doing it then. I'm speaking.
All right, and you are, sorry?
Phil Arnold.
Okay. If I could just run through the procedure then for this morning. The licensing officer or other council officer will present the report. The applicant will make their application. Questions of the applicant by all parties, that's members of the subcommittee. Responsible authorities and other persons will then be given the opportunity to make their representations. Questions of the responsible authorities and other persons, members of the subcommittee, will then ask questions if required. The parties will be given the opportunity to sum up, with the party who spoke first to go last. The subcommittee will then retire to make its decision, and then the subcommittee will return and the chairman will announce the decision if appropriate. A written decision notice will be issued following the hearing in accordance with the regulations. The legal advisor will advise parties of any right of appeal as appropriate. So, first of all then, introductions. On my left.
Thank you, Chair. I'm Joseph Tyler, Democratic Services for BCP Council, and I'm the clerk to this subcommittee today.
I'm Mary Almeida, lawyer for BCP Council, and I'm in training today.
I'm Joanne McNamara, lawyer, BCP Council, and I'm legal advisor to the subcommittee.
I'm Trudy Barlow. I'm the licensing officer for this case.
I'm Nananka Randall. I'm the licensing manager for BCP Council. I'm here to support Trudy.
I'm Philip Day, solicitor from Lacey's. I'm here to represent my clients. That's Sean de Comet, who sits to my right, and Wendy Lovett, his mother, who sits to my left. The young lady at the end is Emma Moscrop. Emma is a trainee with us, and she too is in training today and will not take part in the proceedings. At least I hope she doesn't.
Thank you, Mr. Day. Could I ask the officer to introduce the item, please?
Thank you, Chair. Good morning, all. The application before you today is to consider whether to grant a premises licence for the basement Whitley Court, Westcliff Gardens. The application is to permit late night refreshment Monday to Sunday, 2300 hours to 2330 hours, and the supply of alcohol Monday to Sunday from 10 to 2330. 31 interested parties made representations based on all four of the licensing objectives, namely prevention of crime and disorder, public safety, prevention of public nuisance and protection of children from harm. The responsible authorities negotiated, the pollution control negotiated an extra condition and received no further representations from any other of the responsible authorities. Should the application be granted and the applicants fail to operate in accordance with their licence and any conditions attached to it, they will be aware that any of the responsible authorities or interested parties may request a review of the licence at any time. Thank you.
Thank you. Can I just ask if members have any question of the officer before I invite the applicant to address the committee? No. Thank you. Mr. Day.
Thank you, Chair. Not so very long ago, Christchurch Borough Council, as it then was, had an unwritten policy that they would always visit premises the subject of any application before coming to a hearing such as this. Mixed views about that. There are occasions when that's not helpful, It takes a huge amount of time. There are occasions when it can be very helpful. On this particular occasion, I think it might have been helpful had you been able to see the premises for yourselves, because they're small and they're in the basement of the Whitley Court Hotel as it is known. I think it's fair to say that, for example, the Environmental Health Officer initially had concerns on seeing this application, but as I indicated in the response that I prepared, he took the time and trouble to come out to visit the premises, and having been there, having had the volume on the sound system turned up so loud that we couldn't hear each other shouting at very close range, and then going outside and not being able to hear a thing, and a couple of other points, he was perfectly content to withdraw any representation that he had made. To try and help you, I took a series of photographs and the like, and if you turn to page 103 onwards in your agenda papers, you will see there a response that I have prepared in respect of the representations, and I have included there a number of photographs effectively taking you round the premises themselves and also the locality to try and describe them to you. There is something of a background to this application, which I've set out on page 106. I'm not going to insult this committee by reading everything that I've already put in there, because I'm sure you'll have considered the papers, as you always do, in great detail. But there was a previous application which excited a large number of responses, and which had been submitted without taking any legal advice. The police had issues with regard to that application, environmental health had issues with regard to that application, and so did a substantial number of local residents. I came on board originally to deal with a hearing that was going to happen with regard to that application. But having looked at it and having considered particularly what the police had to say, the terms upon which the application had been submitted, and the fact that it's within a cumulative impact area, the only advice that I could give Mr. Kmet and Mrs. Lovett was to withdraw that application and start all over again. Unfortunately, it appears that some of those who have made representations on this occasion, making those representations on the basis that you're still considering the original application rather than the application that is actually before you and which is set out at page 35 onwards of your agenda papers. It is radically different because the hours are restricted. It also does not include any form of regulated entertainment. As you will know, not least because you've just heard a review application all about the Live Music Act. The Live Music Act applies to any premises in particular that is licensed for the consumption of alcohol on the premises, and it does allow that to happen without it being included on a license, but only up until 11 o'clock at night, and only during the hours that are covered by an alcohol license. And as you will know, it is open in the case that you just heard, environmental health, but in reality, anybody else. And as has been mentioned by your licensing officer, Ms. Barlow, an application for review can be made at any time, and one of the things that can be sought is, as was sought earlier on, an application to disapply the Live Music Act from any premises if it causes a problem. I mentioned cumulative impact, and the majority, if not all, of those who have made representations have done so on the basis that there is a cumulative impact policy, and therefore there is a presumption that the application should be refused. I'd like to draw your attention, please, to the statement of licensing policy that you are currently operating under, which is the Bournemouth Borough Council policy that was adopted in March 2015 and commenced on the 21st of April 2015. That policy is in the process, as is the policy for Christchurch and that for the former Borough of Poole, being replaced by a new BCP-wide policy, which is currently out for consultation. But this is the one that applies at the moment. 1512 of 1511, let's start with that. Where representations are received in respect of applications in the stress area for new premises licences or club premises certificates or variations for premises currently licensed, the following will apply. A presumption will be made that the licensing authority will refuse such applications if a relevant representation is received in regard to any of the licensing objectives. But it goes on to say this. This special policy is not absolute. Upon receipt of a relevant representation, the licensing authority will always consider the circumstances of each case and whether there are exceptional circumstances to justify departing from its special policy in the light of the individual circumstances of the case. If an application is unlikely to add to the cumulative impact of the area, it may be granted. The impact can be expected to be different for premises with different styles and characteristics. For example, while a large nightclub or high-capacity public house might add to problems of cumulative impact, a small restaurant, pub or theatre may be considered exceptional circumstances. Some types of premises may not have so much of a detrimental impact upon the crime and disorder objective and in fact may enhance the character of the area. The licensing authority does not wish to discourage the development of such premises. In addition, the licensing authority recognises that there may be broader community and economic benefit widening the choice and type of venues provided. The fact that the premises will be or is exceptionally well managed with a well-qualified applicant or that there are no residential premises nearby will not be considered exceptional. So in that regard, that's irrelevant, and obviously that works both ways. And what my submission will be, in effect, that for all of the reasons that I've set out in the written representation or the written response that I made, is that this falls fairly and squarely within the sort of thing that you might consider to be exceptional circumstances. But this business with regard to the cumulative impact policy does go a little bit further, because as you will be aware, the order of events are that you obviously have to take account of the Act and the regulations. You also then have to take account of the guidance issued by the Secretary of State at a national level, and then the local guidance. And the guidance that's been issued at a national level is slightly different because it's been updated to take into account the fact that there is now a statutory basis for cumulative impact policies, although that hasn't come into effect in this part of the world yet. What it says is this, and forgive me if I read all of this, because it is important, and I think it's important in particular that members of the public here present should be aware of it, because it addresses the approach that you must take. So what it says is this, and this is a paragraph 1440 of the revised guidance. In publishing a CIA, that's a cumulative impact assessment, which BCP Council has not done. There is no cumulative impact assessment that has been published. But you need to read on. A licensing authority is setting down a strong statement of intent about its approach to considering applications for the grant or variation of premises licences or club premises certificates in the area described. Having published a CIA, that hasn't happened. A licensing authority must have regard to the assessment when determining or revising its statement of licensing policy. It is therefore expected that, in respect of each relevant application in the area concerned, the licensing authority will be considering whether it is appropriate to make a representation to its committee as a responsible authority in its own right. Now, pausing there, the licensing authority is a responsible authority in its own right. Your officers, and they have Chinese walls to achieve this, as I'm sure you know, are perfectly entitled to make a representation, but in this case it is of some significance that they have not. It is of far greater significance that neither the police nor the Environmental Health Department have made representations, because, as you will be aware, both from your own policy and from national policy, and in terms of matters of crime and disorder, you take your lead from the police. Please don't think for one moment that I'm suggesting that the police endorse this application and support it. That's not the case. They simply make no representation. They certainly don't object to it, as they could have done on the grounds of cumulative impact. To go on just to read the rest of it, the CIA does not, however, change the fundamental way that licensing decisions are made. It is therefore open to the licensing authority to grant an application where it considers it is appropriate and where the applicant can demonstrate in the operating schedule that they would not be adding to the cumulative impact. Applications in areas covered by a CIA should therefore give consideration to potential cumulative impact areas when setting out the steps that will be taken to promote the licensing objectives. Where relevant representations are received and the licensing authority decides to grant an application, it will need to provide the applicant, the Chief Officer of Police, and all parties who have made relevant representations with reasons for granting the application, and this should include any reasons for departing from their own policy. CIA must also stress that it does not relieve responsible authorities or any other persons of the need to make relevant representations where they consider it appropriate to do so for promotion of the licensing objectives. And then this is an important part. Anyone making a representation may base it on the evidence published in the CIA. They can't in this case because there is no published CIA. Or the fact that the CIA has been published. We don't have a published CIA. We have a policy, but not an assessment under the new provisions. It remains incumbent on all responsible authorities and other persons to ensure that their representations can withstand the scrutiny to which they would be subject at a hearing. As with all licensing applications under the 2003 Act, if there are no representations, the licensing authority must grant the application in terms that are consistent with the operating schedule submitted. And on it goes. So what do you have here? Well, as you already know, this is a basement below what still is called the Whitley Court Hotel. It is entirely separate from the rest of the building. There was a staircase connecting the two parts, but that has been sealed off. You cannot get from the ground floor or any other part of the hotel building, which has been used as a HMO for many, many years now. You can't get directly from one to the other. You have got to go outside, round, and down the steps and so on that you see in the photograph. This is a small premises, maximum capacity 60 people, partly because fire risk assessments and all that sort of thing. Fire authority is completely satisfied with regard to the provision made there, but it is 60 people. The bar is tiny. There are photographs of it that are within the bundle that I have provided. It is less than the width of the table that I'm sitting at, and at the moment the only drinks that are served are basically in bottles, and that's both soft drinks and alcoholic beverages. And at the moment there is no beer tap, no draft. It is possible that in the future there may be one, but because of the nature of the premises and its usage, the consumption, sale of alcohol in here is going to be pretty restricted. What about its usage? It is a space. It's been described as an event space. In a sense, that's a little unfortunate because people tend to associate the word event with noisy things and so on and so forth, rather than something that is simply happening. These premises have already been used for a variety of non-licensable activities. They have yoga meditation classes taking there. They've had children's parties taking place there and the like. No alcohol, no regulated entertainment or anything of that sort, and absolutely no problem whatsoever to any of the neighbours. And that usage can continue regardless. But of course, such usage then, without a licence, is completely unregulated. No conditions would or could apply. The application is restricted. It is standard old-style unlicensed hours. In other words, until 11 o'clock at night. The premises occasionally opening earlier than that at 8, but the supply of alcohol not starting until 10. And as is commonplace with any unlicensed premises, you always allow a bit of drinking up time at the end so that you have late night refreshment. In other words, in plain English here, tea and coffee available up until the last minute when the doors close at a maximum of 11:30 p.m, which is what would be permitted under the licence. Without a licence, it can stay open all night long because there's nothing to restrict it. But to suggest that because there's late night refreshment limited to 11:30, the premises could carry on operating for a long time thereafter will put them in breach of their licence conditions. There are substantial conditions that have been proposed. It's fair to say that some of those, a significant number of those, partly came about because of the police response to the original application. They wrote a couple of pages saying, we would like to see this, we would like to see that, etc. An awful lot of that, when I went through it, was, dare I say it, pretty standard stuff. It was the sort of thing that I would expect to see in any application and so on, but made specific in respect of these premises. As a direct result of that and restricting the hours, etc., the police decided not to make any representation with regard to this. There are various other things that have come up, and I don't propose to deal with each and every one of them, but I can if need be. Parking, for example, if you know the locality, there is a large car park literally just round the corner, a public car park. Parking there is not an issue. Yes, it is in the cumulative impact area, but to compare Westcliff Gardens with, for example, Horseshoe Common or Old Christchurch Road at 2 o'clock on a Saturday or Sunday morning, it does not bear any comparison whatsoever. This is, if there ever was a case that fell within your policy of having exceptions in exceptional circumstances for small, and I put it like this, pretty harmless premises, then this is it. Having that facility available so that people can book the premises and have alcohol for a birthday party, a retirement party, a works meeting, a bar mitzvah, christening, but also specifically, funnily enough, wakes. It is the sort of area that could be properly and easily made available during the daytime for families and friends who have just attended a funeral or cremation. And that's the sort of thing that this space could be used for, and in respect of which it would utilise the alcohol licence which is being sought here. This is not an application for a nightclub. It's not an application for a noisy premises, and I can tell you, having been there, and I've also recited within this word for word the exchange that we had with Mr. Hill, that you can turn the sound system up there as loud as you like. You go outside, you can't hear it. It's as simple as that. Because of the nature of the premises. It's completely insulated and so on and so forth. I don't really think that there is a great deal that I can add. There are Numerous things that are irrelevant. The situation with regard to planning. Planning matters are currently being dealt with for the site as a whole, not simply this part. The usage of the basement is long established as being part of the hotel. It's always been a function room for the hotel, although not being used as such quite clearly for a significant number of years. But that's not relevant in terms of considering the application that's before you, which is the licensing application. Yes, I accept it comes within the cumulative impact policy, but you have to be satisfied that issues there have been properly raised in the absence of a cumulative impact assessment that covers any part of the BCP area. Come to that. It is within policy to make exceptions. And I would suggest that because of the nature of the premises and what is proposed, that this is clearly an exception, and there is absolutely every reason why you should grant this application as applied for. Mrs. Lovett, Mr. Clement, here to answer any questions that you, or come to that anybody else may have. As I've said, I'm not going to take you line by line through the response that I've made. I'm not going to deal with every single point made in every single representation. If there is anything that you or anybody else present would like more information about, would like to ask us about, then please feel free. But with that, I will end my initial presentation.
Thank you, Mr. Day. Do members have any questions of the applicant at all? Okay. Mr. Day, can I just ask, I understand that there was an issue with a party back in November which was held at the premises. Are you able to expand on that for members at all?
Two events took place. The second of those, I can't remember the date, but I can give you the information. Temporary event notice was given, and the event took place with the sale of alcohol without any issue, any difficulty whatsoever. The one to which I think you were referring to was a non-licensable event that took place round about Halloween, where a number of friends and family were invited to the premises for an entirely private celebration. There is a dispute about what happened on that occasion because some complaints have been made about it, but my very firm instructions are that party, event, whatever you want to call it, finished at 11 o'clock, and that anybody and everybody who was associated with that left the immediate locality quickly and quietly. But it was not a licensable event.
Thank you for that. If members have no further questions for the applicant, could I then move to other persons wishing to speak? Could I ask if Mr. Stephen Nichols would like to... I was given a note that Mr. Stephen Nichols wished to speak first because he had an appointment to attend. Okay, thank you very much. I'm only acting on the information that I've been given. Sorry. In which case then, Councillor Beasley, would you like to address the committee, please?
Thank you very much, Chairman. I'll do the best I can with my voice. I've been suffering, as many others have, with the bug that's been going round. It isn't often that, as a ward member, I get involved in licensing applications. It's only when a body of residents feel that there are issues which need to be addressed and be supported on that I do so. I've been ward member for Westbourne and Westcliff for a considerable length of time, approaching 20 years, and obviously there is a lot of licensable activity within the ward, and hence the cumulative impact issues that Mr. Day has been speaking about. So in terms of representing residents over quite a considerable time over the premises, my submission around the licensing objectives focused very much on the prevention of crime and disorder, and my perception that the applicants will find it very difficult to prevent, particularly around access and egress to the premises, and that the introduction of the sale and consumption of alcohol will be incompatible in terms of adding to the risks of crime, and particularly in this vicinity around issues concerning drugs. Now, that might not be fundamentally an issue for the granting or not of this licence, but I do raise it because it is a considerable issue for the police, and the actual dealing and use of drugs is a present and real problem in the vicinity. In terms of public safety, the second of the licensing objectives which I have cited, I base that very much indeed on the experience of other licensed premises in the vicinity. And it's a matter of fact that antisocial behaviour is something that ebbs and flows on the West Cliff, but it does tend to revolve around licensed premises in almost all cases. And thirdly, the prevention of public nuisance. And I think this really gets to the nub of one of the principal issues for local residents, and that is the increased noise and disturbance from additional licensed premises, and the difficulty to control that, particularly on exiting the premises and in the vicinity of exiting those premises, and the harm that then causes to local residents, particularly in terms of their peaceful enjoyment of the places in which they live nearby. The area is a mix of licensed premises, hotels and residential. I would suggest that this very small locality is predominantly at present residential. Nevertheless, the other uses have to live comfortably alongside. And I think that within all of this, the reasons historically for it being made a cumulative impact zone become apparent when you walk around the immediate vicinity of the Whitley Court. So the issue of residents' right to peaceful enjoyment of their homes is absolutely fundamental to this. And I suppose the points made earlier around the cumulative impact area are fundamental from the point of view of granting a licence for these premises. There are a number of issues which came through in the paper that Mr. Day put out on behalf of the applicants. There's been no direct dialogue between me, they, or him as their licensing solicitor, but his paper does raise some points which I think will need to be considered by you in determining the application. If we could just deal, first of all, I think with those that relate to how the premises will be operated, and the ability or otherwise of door staff or indeed enforcement of aspects such as the doors which Mr. Day was referring to a moment ago. Those are issues which will only work if there is proper enforcement activity on the premises themselves. And one of the concerns around that is that whilst I fully appreciate that the Senior Environmental Health Officer, Andrew Hill, has visited the premises and has done the tests around noise, one of the conditions referred to within there is that At all times, the premises are open for licensable activities, either the door leading into or out from the premises, or the door between the entrance lobby and the function room itself, or both, will be kept closed, save for normal access and egress. The obvious question, therefore, is how will that situation be maintained and who will actually enforce it? Experience tells me that unless that happens, the condition is pretty meaningless, because actually, however good the preventative measures are, they simply won't work unless that is actually monitored and enforced. So that is an issue which, in terms of noise and disturbance for local residents, I think is important. Next, I come to the point that you raised a moment ago, Chairman, which was regard to the issues that took place on the 3rd of November. I think that the notes that I have from local residents is that there were witnesses to this antisocial behaviour, that there is CCTV on adjoining premises, but more importantly, Chairman, rather than the specific event, is how will the management of the Whitley Court be able to ensure that there isn't noise and disturbance for residents at the time when those people are leaving the premises or indeed going outside to use the smoking area. Those are very real and present issues, and relatively late at night with a huge number of residential properties, many of them occupied by elderly people. Having noise and disturbance late at night is certainly not something which they would either welcome or expect to take place. So I think that how that is managed and how it is monitored and enforced, again, Chairman, is really important. There's been quite a lot of speculation, and that won't be necessarily a matter for you as far as these premises are concerned, but local residents do judge the behaviour and management of premises very much by how they're conducted at the moment. And there has been, over a period of time, not just concerning licensing, but particularly around planning issues, which are not a matter for you, I fully appreciate, an ability by the applicants to draw attention to themselves around regulation and planning issues. And that has meant that local residents have been keeping a very careful watch on everything that's been taking place, and want to be absolutely certain that if you do grant a licence today, that the conditions attached to it are ones that will be monitored, they will be enforced, and that the reasons why there's a cumulative impact area in place will actually be negated, and so that their quiet enjoyment isn't disturbed. There is speculation, but I think quite warranted, and I think that therefore these conditions do need to be properly looked at. One of the concerns has been about why such small premises are so important to this particular building, which is fundamentally a house of multiple occupation. Although I understand that there are moves afoot to change that in part, and I have that on good authority of the planning enforcement officer. And I do have here something I would like to read out because it's relevant to something I wish to say in a moment. And the planning enforcement officer, Karen Fairclough, committed to writing at the beginning of November.
Sir, I have a real concern, particularly coming from Councillor Beasley, that new material being introduced at a hearing without any warning whatsoever. It is contrary to the regulations unless all parties consent. And I'm not happy, particularly as Councillor Beasley has said himself, that planning matters are irrelevant, with him then wanting to refer to emails that he appears to have had for a couple of months and which have not only not been disclosed, but not even previously been mentioned in his representation. I object to this.
Thank you, Mr. Gay. Councillor Beasley, we are here as the licensing authority, and the planning matters are totally separate from what the committee are here to look at this morning.
I fully accept that, Chairman, and I fully accept Mr. Day's intervention. but it may well turn to be relevant at a later stage if you are to grant this licence today, because I'm not sure that everything is quite as it appears to be. I'll move on from there, though, Chairman, dealing with other matters that are within Mr. Day's submission. And I say again that I haven't had any discussion with Mr. Day as the applicant's solicitor, nor indeed the applicants themselves. They haven't communicated with me, so I rely on what it is that he has sent you and me and local residents. In terms of the cumulative impact area, Mr. Day talked at some length around the need for it to be exceptional circumstances, because there is a presumption against the grant of a new licence unless the applicants can demonstrate that the grant would not have a negative impact upon the licensing objectives. It's my view that they haven't actually managed to achieve that. And the issue of it being exceptional circumstances due to the small scale of the premises, I think, doesn't actually go far enough in terms of proving that there would not be a negative impact upon the licensing objectives. The licensing objectives, that the reasons I've put forward, I don't think will be impacted by the fact that these premises have a total capacity of 60 people. Indeed, I don't think that that is the issue at all. I think the issue is far more about access and egress to those premises, and therefore, at the time of day that that is going to be a real pinch point, I believe will have the greatest impact, even with a maximum capacity of 60 people. Mr. Day also made some play around the fact that the police have made no representation on the CIA issue. Indeed, I know that they were very concerned on the previous application, and they haven't done on this one. That isn't actually an endorsement by the police. It's a position of neutrality, and I can well understand why they have taken that position. Again, I don't think that that diminishes or dilutes my objections around the licensing objectives made in my submission. I think the final issue that Mr. Day was making around the cumulative impact area, which is that you as licensing committee will need to make a statement justifying departure from policy, is one that may well be important in terms of holding the licensees to account should you grant the application today. I think finally, Chairman, at this stage, the point I really wanted to make was that there are a number of conditions that are being attached to this application. There is a high degree of interest from local residents about the conduct of premises within this vicinity, and they will be keeping a very close watch if you are to grant this application today. And there is always, of course, the sanction for review, and that can be commenced by me as a ward member, commenced by local residents. I certainly hope that in those circumstances that would not become necessary, but if it does, that will be the sanction that will be invoked without any hesitation. Thank you very much, Chairman.
Thank you, Councillor Beasley. Mr. Day, there were a number of points in there which I'm sure you clearly want to address. Would you like to do that now, or would you be happy for the other representations to be made and then address the issues at the end?
I'm entirely in your hand, whichever you and your fellow committee members would prefer. I don't mind.
My preference would be to hear from everybody.
Fine.
Because they may have the same issues, and then you can address them all in your summing up.
That makes entire sense.
Thank you very much. What I did fail to admit was that representatives may ask questions of the applicant and vice versa. And I'm sorry about that, Mr. Day. But anybody making representations this morning, did they have any questions for Mr. Day, or would they prefer to do it when they make their representations?
I would prefer to do it when I've given my presentation.
Thank you. Everyone happy with that? Thank you very much. Members, did you have any questions for Councillor Beasley at all? Yeah. Mr. Barron.
Thank you, Chair. Actually, reading through the paperwork, there's lots and lots of complaints, and there's an incident of urinating there. And to be fair to the applicants, I think we really need to establish that was that connected with the party. I mean, it could have been somebody just wandering up from Bournemouth. I mean, how do we actually know that it was connected to the applicants? We must be fair here, really. Thank you.
Mr. Knapp?
The event that was referred to, and then looking at the representations, the times don't add up at all. It is close to town. People do head up that way after nights out. There's no way to say that was someone who attended the private event that night. And looking at the timings, it was a bit frustrating to see the representations, and I sympathise with the local residents. And you can see how it could be related, but I really cannot see. I was at the event much later, and that anyone who attended had left long before those timings on the representations. Thank you.
Thank you, Mr. Knapp.
Questions to Councillor Beasley, if anyone's got any questions.
Anyone have any questions at all for Councillor Beasley while he's still at the table? No? Thank you. In which case then, can I call upon Mr. Stephen Nichols, please, to address the committee?
Thank you for allowing me to speak. I'm objecting to the application opening in an existing HMO registered for 28 permitted occupants on the grounds of public nuisance and prevention of crime and disorder. Of concern are the outside patios being identified as a noise problem. The amplified music will be played with a lack of noise limiting equipment. And that how will the door system that's been installed alleviate noise? And that no preventative action to ensure that glasses and bottles will not be taken from the premises. I've heard no measures proposed to assure the police that crime and disorder objectives would be upheld. This will be to the detriment to an area that is both residential and given over to our valuable hospitality industry. With respect to Mr. Day, granting this licence will add to the existing problems of antisocial behaviour on the edge of Bournemouth's cumulative impact area, where there is already on-street drinking and will only serve to exacerbate the problems already experienced by businesses, tourists and residents in the Westcliff area. The Westcliff is a location where Dorset Police and our council officers are already working in an area that's plagued with high levels of antisocial behaviour, drug dealing, disorder and abusive and intimidating behaviour on a daily basis. Granting this application will increase antisocial behaviour and will result in noise and parking management issues. With respect to Mr. Day, parking management issues will indeed become an issue if the Government Inspectorate grants planning permission to develop the Durley Road car park for residential use, which is adjacent to the premises that require a licence. The residents in the area are concerned that the applicants will not uphold the objectives set out in the Licensing Act of 2003, namely the prevention of crime and disorder, the prevention of public nuisance, public safety, and the protection of children from harm. To allow yet another outlet that supplies alcohol would undermine the licensing objectives. You'll be aware that from research within the A&E unit at Bournemouth and Pool's hospitals, there's been a significant increase in the number of patients being screened for alcohol misuse. By rejecting this application, this will alleviate pressure on Dorset Police and the South Western Ambulance Service. Rejection will prevent an increase in noise and antisocial problems. And finally, by rejecting this application, it will enable the tourists, residents and local workers to get a night of undisturbed peace and quiet. Thank you very much for your time.
Thank you, Mr. Nichols. Did members have any questions for Mr. Nichols at all? No. Mr. Day, do you have any questions for Mr. Thank you. Could I then call on Mr. Burton Smith? Thank you.
Mr. Chairman and board members. So my family
Would you like me to start again?
No, you're right.
I must thank Mr. Day of Lacey Solicitors, my family solicitors, for the glossy response to representations made by local people, and I compare it to a Thompson's holiday brochure. Very glossy, wonderful pictures, but lacking any relevance to the actual destination, with plenty of small print masking the actual facts. And as I am marching on in my years, with my first meeting with the good Lord, I do hope solicitors, laces, employ Mr. Day to read my will with the same imagination and zest that the bar beyond have replied in their representation. To grant a licence to a premises or person, the committee have to decide that the applicants are, amongst other things, other criteria, fit and proper people to hold such an important piece of paper and to carry out their responsibilities. I cannot comment on the applicants personally, as I have never met them. But I do know from the experience of seeing how this business plan has been executed for the last 210 days, 7 months, I have no confidence that they are fit and proper people to hold such a licence. How do I reach this conclusion? One only has to go back over these 210 days, and possibly longer, to form the same opinion that I have. I will not go into great detail, like Mr. Day doesn't want to, otherwise this meeting will still be operating the following days. You will have heard the total rejection of the application to grant a licence to Whitley Court HMO. Mr. Day calls it Whitley Court Hotel. That is the name, but the actual property is still registered, according to the 2008 planning application, as an HMO, not a hotel. Local businesses in the proximity of the area, which is the Tower Court Hotel, the Sands Hotel, the Riviera Hotel.
Mr. Nichols, can I ask you to keep your information that you wish to the committee to consider to the premises that are being applied for in the licence? The HMO or hotel, whatever it is not part of what the committee is considering this morning. It's purely the application that the applicant has put before the BCP Council to licence those premises, not the HMO.
Okay, thank you. I'm sorry about that. Being a local people, we only have our own views, don't we? So there we are. Right. As stated, as I was stating to you just then, Westcliff Green area is an area of predominantly elderly hotels, like the Whitley Court Hotel was, like the Tower Hotel, like the Sands Hotel, and they cater for the elderly people. You don't see youngsters there, you only see normally my age group, families, people taking their grandchildren with them. So To have a young, vibrant club, events place, or whatever you want to call it, is totally out of character for this area. One question I have to ask is, who would want to drink at 10 o'clock in the morning? If they have got these mothers' meetings, as they stated, or whatever meetings they have, why do you want to drink at 10 o'clock in the morning? You could actually drink at that establishment from 10 in the morning till 11 at night, and then for half an hour have a few nibbles to sober up. That is not what Westcliff Green area wants. We don't want that sort of thing. We want family entertainment. The families that come down on holiday want that sort of entertainment. Bar Beyond will not be able to give it to them. We've got the problem of the Durley car park, which Mr. Day has said. We don't know what's going to happen to that. You can have, actually, in theory, 60 cars parking in that area. I'm not going to say that's the worst scenario, and the best scenario would be 0 cars parked in that area. But it's going to happen. We struggle at this point of time, residents do, to park in that area. We've got the same problem with antisocial behaviour. We don't get it on Westcliff Gardens. It stops at the St Michael's there. We have a community impact area, like Mr. Day has quite clearly pointed out. Why was it set up? It was set up for a reason, to stop these sort of places getting larger and larger and larger. We don't want it. There's no need. The hotel, if you want entertainment in our area, you go to the hotel. You go to the Sands Hotel and you go to the Tower Hotel and listen to the entertainment there. And then at 10 o'clock you either stay in the hotel or they leave. It really does concern me that for 210 days this company has circumnavigated this application here today, and it's down to you guys now to decide whether the residents, and there's 31 people made objections, 31 people, but probably 200 people in the background who do not want to make a fuss like everybody else does to do this. The application from the police, who have not objected, I agree with Mr. Day here, they have not objected at all, raised a lot of concern with us in the fact that the same officer, Sergeant Goslin, stated at a planning meeting earlier at Christchurch that extended drinking licence does have a cumulative effect on the area. That was for Christchurch. We are in the CIA's area, so it's still going to add even more problems. Like my colleague has just said, the police will be involved. Whether they come out is another matter. We know they stretch. We know that. There's no need to have this sort of attitude. They have not shown in any of their forthcomings what control they're going to do outside of the door. Inside the door, yeah, I accept that they will probably have staff to regard it, but outside the door, there is no policy. There is an area outside for drinking, for drinkers, smokers. 10 people, that is their condition. You can have 10 smokers out there, but you can have 45 to 50 people who don't smoke. The noise, the talk, the loudness going up to Avon Court, which is probably only about 40 feet away. They've never had this problem before. Why should we let those poor people who've lived there for years have this problem again? For what? What benefit will this club bring to Westcliff Green? It'll bring nothing. What problems in the presumption of not allowing a licence, what positives are they going to show us? Nothing. That is the resident. I'm talking from the resident's point of view. Nothing at all. So, in conclusion, I strongly urge you guys, the committee, to reject this application, and I do thank the committee for putting me right on certain points and allowing me to present my case.
Thank you, Mr. Nichols. Okay, legal officer just wants to address the committee and those present.
I just wanted to clarify that.
I'm afraid you have to start.
I just wanted to clarify. You made reference to a fit and proper person test. That's not a test that's relevant to licensing law.
But surely, to hold a licence, you hold responsibilities, and responsibilities, as deemed by you guys, have to be carried out correctly.
But a fit and proper person test is not the test that the subcommittee needs to take into account today. I just wanted to clarify. That's fine.
Do members have any questions for Mr. Nichols at all? No. Mr. Day, any questions at all for Mr. Nichols?
Just one. Mr. Nichols, a few days ago, you sent an email to licensing department attaching a text of an email that you'd received from Sergeant Gosling. You indicated that you wanted to refer to that, or may want to refer to it at this hearing. Do you want to refer to it? Because if you do, I'm perfectly happy for you to do so. I've even brought copies. I do apologise. The email is addressed to you, but it was you who sent it, was it? Right, well, fine. Then I'll leave it until you have yours.
On that point, I've entered into quite deep discussion with Sergeant Gosling on not his decision, because that is what he's paid for to do, but the way he derived at that decision. And I've actually, at this point of time, I'm sorry.
It's okay. Would members like to see the copy of that email? Yeah, okay. If you'd be so kind, Mr. Day. Thank you, Mr. Day, for distributing that email. If there are no questions for Mr. Nichols, further questions for Mr. Nichols, can I ask Mr. Burton Smith? Oh, beg your pardon. Okay, so the next is Mr. Patuici. I hope I've pronounced that correctly.
Good morning, Mr. Chairman, committee and all. I would like firstly to expand on some issues in my representation. Public speaking is not my forte, So I would ask for your forbearance as I read through my points. As regards all 4 licensing objectives, the police, represented by Sergeant Gosling, revealed in an email on the 27th of November that they believe the applicants have agreed to a number of conditions, including reduced operating hours, which were inserted into application 171899. My contention is that they have clearly not checked the detail of application 174055 and have wrongly assumed the latest application contains the same conditions. My representation painstakingly analyses this issue, making the point that a considerable number of conditions mediated before have either been watered down or dropped altogether, and pointed out what's now missing or changed. 2 quick examples. The police previously set a premises closing time of 23:30. 174055 has no closing time. The police previously set an alcohol supply start time of noon. In 174055, alcohol is available daily from 10 a.m. In a word, if the police were to...
I'm sorry. You're dealing with the applications before you, not a previous application.
No, I'm talking about this application.
You're talking about a previous application which was withdrawn. This is a different application and obviously is subject to different conditions.
No, I'm sorry, I'm speaking in respect of what's happened.
We're talking about the previous application that the police officer is using as well as the current application.
No, if I could just intervene, the previous application is redundant and a new application has been put before the council. This is the application that the committee will look at this morning. And in my copy, it's numbered as 174055. Anything that has gone before is redundant.
But what I'm going to go on to say is, in a word, if the police were to re-examine the application detail, they would not be able to accept it. In my representation, I ended paragraph 4 with the comment, I cannot imagine Dorset Police has agreed to the changes.
Mr. Padawici, can I just ask the licensing legal officer to just put you correct on what we are looking at this morning at this committee meeting, please?
I think what's happened in the past, and correct me if I'm wrong, that the previous application was put in, the police made representations in relation to that, and then that was withdrawn and the new application's been made. And I think what you're saying, sir, is that you're comparing the police's comments in relation to the previous application as to what is now being put before the subcommittee today. Is that right? Is that what you're comparing, the police's previous representations?
No, the point I want to make is that when Sergeant Gosling refers to reduced operating hours in that email he just seen, he means the police reduction from 2430 to 2300 hours with a set premises closing time of 2330, whereas Bar Beyond P Day has now increased the alcohol hours.
I think for the purposes of today's hearing, that the police haven't made a representation. And as you can see in the email from the police, he said, Sergeant Gosling says, to be clear, we're not supporting the application. It is our role as a responsible authority to engage with applicants and work with them to achieve the best possible outcome with prevention of crime and disorder at the forefront of the efforts. I'm satisfied that we have achieved this. So the police are saying in this email that although they may have made representation to the previous application, which was withdrawn, in relation to the current application, they are saying they are satisfied that the terms and conditions in this proposed licence achieve what the police were hoping to achieve before. So
but we don't have any evidence that they've actually studied the latest.
We have no evidence to say they haven't, but what we have is the email. So for the purposes of today's hearing, we are only looking at the application 174055.
4055, which was received by the council on the 30th of October. And Sergeant Gosling's email addresses that in terms of the date, which was the 27th of November.
I wonder if the licensing manager can clarify some points.
I just want to clarify for you that all applications are forwarded to the police and all the responsible authorities for consideration, and actually we have regular meetings with the police where we discuss each application. So I can completely confirm to you that Mr. Gosling looked at this application and chose not to make any representation because he was happy with the conditions that were put forward in this application. So there is no doubt in my mind that he was fully aware of what was the contents were of this application.
Okay, accepted. I mentioned change of use. Arguably, to run a venue or licensed operation, planning permission for change of building use should be obtained first from the council. In connection with the prevention of public nuisance, a licensed venue operation right in the middle of residential properties is totally the wrong location, which is why 31 people have objected. The conditions fail to specify whether entry to and exit from the premises would be via the premises front entrance, but Mr. Day's submission now states that entry and exit will be via the rebuilt rear yard staircase under a new unauthorised canopy and unauthorised bar beyond signage. This will aggravate the noise and disturbance for adjacent local residents like ourselves. Moving on to the response from Lacey's, my comments are as follows. Paragraph 1, page 1, paragraph 1, obviously the ladies explained that, so I'll say nothing on that one. Page 2, paragraph 1, the staircase is without planning permission. Page 2, the toilets. 2 toilets for up to 60 people seems insufficient provision. Page 3 at the top, since not all doors are fitted, I don't believe they have a fire certificate now for 60 people. The description reads like a potential fire death trap such that the venue should never be allowed to function.
Mr. Pazuiti, I'm sorry, but the committee is here to look at the licensing objectives, not planning, not fire regulations, purely the licence application for the premises. If you could stick to those points, I'd be most grateful. Thank you.
Okay. Page 4, the background. Mr. Days omitted to give a correct picture in that he's omitted to advise that on the 3rd of September we had an email from licensing advising that police conditions had been accepted and we needed to update our representations by the 25th of the 9th. And the key police conditions were, as you know, much stricter. And then we had on the 10th of October that application was withdrawn and replaced by the current one, which contains watered down conditions. In page 4, the penultimate paragraph, I have to question this statement as both Facebook and Bar Beyond website state that live music or a DJ is an option for any event. So when it suits, there will be a form of regulated entertainment, albeit permissible under the Live Music Act. Hence, the paragraph seems misleading. Page 4, last paragraph, I would say that's not true because we now have longer alcohol hours proposed of 10 to 23 instead of 12 to 23. And no mention of a premises closing time in the application. Page 5, paragraph 1. The opening closing times should have been advised in the published conditions in October. And Lacers are now proposing opening hours of 8 till 23:30, but these times, not being in the conditions, can doubtless be amended on a whim. Page 5, paragraph 2 is not correct. There is no Avon Court, it should be Avon House, which is immediately adjacent and hence the most affected. And the Westcliff Garden objectors are nearly all residents too and not proprietors. Page 5, where the applicants. Sandbanks has been mentioned by objectors, firstly because of their family connection, like father, like son, but more importantly because of the business model pursued, which is the stag and hen partying going on at all the wrong hours. This makes big money and is what Bar Beyond will be seeking to replicate. Page 5, nightclub paragraph. There's nothing in the latest conditions about entry control. Page 5, noise. This was a small-scale partial test. The outcome could be expected to be much more adverse if a live DJ or singer was engaged, as offered by the website or Facebook. But so that hasn't been tested. Page 6 at the bottom, as regards planning comment. Planning enforcement has raised a large number of issues, and the different
Mr. Patovici, once again, I say we're not here to look at planning application conditions. We're here to look at the licensing application.
In page 7, paragraph 1, we dispute that the function room is long established, since the HMO licence is for 28 people in 4 stories, which includes the basement. Page 7, paragraph 4 is disputed. We have witnesses and some CCTV evidence. Page 7, parking availability. The council has twice attempted to sell Daly Road, so possibly a time-limited option. And venue visitors may also be...
Mr. Patovici, this is not relevant to the application.
Okay. Page 8, paragraph 2. Not true. If food is served till 23:30, leavers thereafter will automatically be part of that so-called nighttime economy. Next point, next not allowed. Page 8, paragraph 4 is not true or disputed. And use of the outside area will create a lot of noise nuisance and daily friction, which will lead to a lot of complaints to the council or to the police. The last part is obviously ruled out by what you said earlier. So that's...
Thank you, Mr. Patovici. Members, do you have any questions for Mr. Patovici at all? Mr. Day?
Can I ask, slightly out of turn, but just so that licensing can confirm the proposed conditions and the end hour, how does that affect the premises being opened or not opened?
The opening hours.
Because obviously
the opening hours are actually in the application. They're very clear. Till 23:30.
And they're set out on the draft licence.
And they are set out on the draft licence. So
in effect, the premises will close at 23:30.
That wasn't set out on. That's not set out on the website.
It's in the papers that were sent out.
The sale of alcohol will finish at 2300 hours, and the premises will close at 23:30, giving the patrons half an hour to drink up. No further questions from Mr. Patovici. Can I just move on then to Mr. Arnold, please?
before he begins, do you mind just excusing Mr. Kmet literally for a couple of minutes? He means you know courtesy. Cheers.
Thank you.
So you're more than happy to continue without him. Yeah, it's fine. It's not a problem with you carrying on.
Thank you, Mr. Day. Mr. Arnold.
Yep, thank you. I wish to object to the planning application. I've got a number of concerns over it. Westcliff.
Licensing application.
Sorry?
Licensing application.
Sorry, licensing application. Sorry. Terminology. Westcliff Gardens is a conservation area and its cumulative impact area, as we all know, is primarily family, elderly orientated accommodation. Mr. Day's painted a very rosy picture of an event premises, wakes, dancing, yoga, etc. But surely the hint is in the name, Bar Beyond. It's not a clubbing area. There's areas for this type of club elsewhere in Bournemouth. It's genteel, it's tranquil. If it gets disrupted, there's going to be a big question mark over those regular holiday makers who would revisit the area in future. And obviously that'll be an impact on the local economy. It doesn't enhance the area. It's contrary, it's not exceptional circumstances and therefore shouldn't be treated as such. In terms of public safety, the entrance to Bar Beyond opens onto a very busy Westcliff Road. There's no parking facilities or dropping off points, there's all yellow lines, and we've got the Wessex hotel development on the other side of the road. Rivellers, Westcliff Gardens itself is particularly notorious for lack of parking. There is none. There are no free spots, and the corner adjacent to Bar Beyond is filled with parked coaches. The fences outside of Bar Beyond actually prevent people from seeing what's happening on the corner of Westcliff Gardens, so there's already an issue in terms of safety. Revellers emerging late at night will inevitably encroach Westcliff Road, causing nuisance, impacting public safety, particularly as taxis will no doubt be parked on double yellow lines outside ready to collect people. And one point about leaving the premises, there are 2 toilets for 60 people who've been drinking alcohol all night. In terms of crime and disorder, there is a big drugs issue in Westcliff Gardens, and I've got photographic evidence. I haven't submitted it, but there's photographic evidence of dealing, people waiting for drugs, and that moves up and down the road, emanating from the green. Bar Beyond is probably about 100 yards away from that, from the green. So to have a function club establishment in that facility will only attract people like that, and we have a real concern over it. The impact on families and elderly, they will become very nervous and they will become accosted, as we've already seen. So there is a real issue of crime and disorder. In terms of attitude and approach, there appears to be a very laissez-faire attitude by the applicant with a number of aspects. The assumption that licence and planning permission will be granted, shown by the amount of unauthorised work that's taken place. The policing response to dealing with issues are when they arise, rather than prevention, mitigation from the outset. Gives us very little confidence, particularly when 101 number doesn't answer for 30 minutes. The police are stretched to the limit. We'd have very little confidence in their presence should any incidents be reported. My objections are based on very simple, very logical reasons that want to protect the facility and its residents. Thank you.
Thank you, Mr. Arnold. Do members have any questions at all? Mr. Day, any questions? Thank you. Mr. Day, would you better assist me? I'm just trying to I can't find it on the application with regards to timings for late night refreshment.
The application starts on page 35.
38, is it?
Yeah, the hours for late night refreshment and supply of alcohol are 38. Of course, late night refreshment doesn't start until 11 p.m, which is why it's 2,300 hours.
Yeah.
And then the opening hours of the premises are on page 39, and as has previously been indicated by your licensing officers, that would form part of the licence. You don't need to condition. You don't need a condition that says sale of alcohol finish at this one. That's actually what the licence authorises. End of.
Yeah. Thank you, Mr. Day. Do members have any further questions at all? No? Right. So we've heard from the applicant and also from other persons making representations. Can I ask if Councillor Beasley, would you like to sum up on behalf of the residents who've addressed the committee this morning?
Yes, certainly, Chairman. I do, though, have a question for Mr. Day from the submission that he made and circulated previous to the meeting. Would you like me to do that afterwards, or shall I sum up first?
What do you prefer?
My page numbers may not be the same as your bundle because I took this extract separately, but I'm sure you have. So if on the page that I've got, if I could refer you to page 7 of 8, and it's the subparagraph, the second one on that page, entitled "The Use in Connection with the Whitley Court Hotel." Yeah. And I just wondered whether the 4 lines that are there you could explain so that I and the committee absolutely understand what it is that you're saying there.
Well, the building as a whole is known as the Whitley Court Hotel, regardless of what usage it may actually have been put to. The application is only in respect of the basement of that physical building. It has separate access, as you can see from the plans, which immediately follow the application, and they would be on pages, there will be 2 seconds. 44 is the site plan, and 45 is the layout plan of the premises themselves. And you will see, if you look at page 45, that there was a staircase from which you could get into the basement from the ground floor of Whitley Court, let me just call it that, to use neutral language, and you can't do that now because that's been sealed off. So it's entirely separate. It's got nothing to do with the use of the rest of the premises, be that as a HMO, be it as a hotel, be it as short-term lets or anything else. It happens to be underneath such a building. It's almost as if I was applying for a licence simply for this room. I'm ignoring the rest of the council offices and everything else that happens anywhere else in this building. Does that answer your question?
It does to a certain extent, Chairman. It doesn't quite drive to the point I was trying to reach, in so much as just being very clear that what is said in that paragraph is the intention of the applicant as to how that will remain in the future.
Well,
in other words, without prejudicing the ability of the applicants to change things in the future, I just want to be clear that what it's saying there is the current and present intention.
But it's not the same as, let's go back to this building. If the proposal was to provide a bar facility for those who work in this building, that would be one thing. If, on the other hand, it was intended to completely seal off this area so you couldn't get to it from the rest of the building without going outside, it is completely independent from the rest of the building, then that is something entirely different. It is not intended to provide a facility for anybody resident in what is above, be that on a temporary basis, be it on a permanent basis, be it on any basis at all. It just happens to be a space that is within the physical building. There will be nothing to prevent anybody who is resident there from going in on occasions, but there is nothing to prevent anybody else going in there either, hiring it, or if it were to be open for a public event, any member of the public could go, including you, me, and regardless of where we live.
So therefore, on the back of that, Chairman, if I could just seek clarification from the licensing officer, that were that arrangement to change, would those be grounds for licensing to review that part of the licence and amend it if necessary?
I can answer that question straight away. The plans form part of the licence. If we were to, for example, want to reinstate that staircase and connect the two so that it became more in the nature of a hotel bar, the primary purpose of which is to provide a facility for those in the hotel, then you would have to make an application to amend those plans. With something of that nature, I would personally take the view that that was not appropriate for a minor variation, and I see Mr. Randall agreeing with me. That means you'd have to make a full variation application procedure to all intents and purposes, exactly the same as a new licence, site notices, newspaper notices, the lot, and one would expect representations.
Thank you, Mr. Day.
Thank you very much, Chairman. I'm grateful for Mr. Day making that clear on behalf of his applicant.
I just wanted the officer to confirm that that's the case. Thank you.
That is the case. The plans are always attached to the licence, which makes it part of the licence. So if there are any physical amendments to the premises, they have to put in a variation, and then that's subject to the rules and regulations of the Licensing Act.
Thank you. Councillor Beasley.
Thank you very much, Chairman. I'm grateful for clarification on that point. It was every bit as much as I was expecting, but I was very pleased to hear it from Mr. Day directly. In terms of just summing up, I will make this brief, Chairman, and I think it's become clear, has it not, that there are concerns reflected certainly in my representation around the licensing objectives. There are concerns by local residents about the implication on those licensing objectives if you are to grant this licence today. And I think fundamental to that is the concern that residents have about the peaceful enjoyment of their own homes, and that the introduction of this new use to these premises would be something that quite justifiably you would expect them to want to be sure that there are sufficient conditions there to address the issues, and that those conditions will be enforced by the management. They will be maintained and they will be enforced by the management. And those were the points that I was making earlier, particularly with regard to the noise issues emanating from the premises, the noise issues on people leaving the premises, and indeed their use of the smoking shelter outside. Those sort of issues do matter to people, hence the reason that you've heard representations today. I think it's clear to me that everybody understands those rules of engagement, which is important, and the issue really remains then that if those are not satisfactorily maintained by the management, they will be opportunity there for residents to use the sanction of calling the licence in for review. That is something which I know doesn't happen all that often, although you did have one earlier today, but it is one that in extreme circumstances needs to be borne in mind. I think the issue around door staff and their ability to actually deal with those issues, both access and egress from the premises, are ones which strike at the very heart of those concerns. And of course, if the licence were to be granted and then managed and conducted in the way that has been explained to us today, I'm sure we will hear no more issues around the Whitley Court. I still maintain, though, Chairman, and I'm sure that local residents would agree, that is more in hope than expectation at this stage, because it doesn't take very much to upset that balance in a local community, and I do hope that you and your committee members, Chairman, will take that into account when you determine this application this morning. Thank you.
Thank you, Councillor Beasley. Mr. Day, would you like to sum up?
I'll try and keep it short. Just for the benefit of Councillor Beasley on the point about review, I would invite all present to have a quick look at the agenda for this meeting. Reviews are not few and far between. You've already dealt with one, and out of a total of, I think it's 8 items, which includes all the formalities such as apologies, electing the chair and all the rest of it, there are in fact 3 review applications. One for the Camden Bar, which you've already heard, another for an off-licence, and another one for a bar which also has a late licence. I know something of both of those for reasons I won't go into. In terms of the overall picture here, I confess to an extent I'm hearing mixed messages. I point to, and obviously I'm going to pick out things that help, but one of those who gave evidence, Mr. Burton Smith, he actually said, and I wrote it down, we don't get antisocial behaviour in Westcliff Gardens. He and others have also said, well, there's no need for it. Well, need is irrelevant. You don't consider need as a matter of licensing any more than you consider planning aspects or this fit and proper person. That actually used to be a test back under the 1964 legislation. You had to go before magistrates and satisfy them that you were a fit and proper person to hold a licence for this particular establishment, whatever it was. But that was before the days of personal licences and BII exams and certificates and having to produce criminal record checks before you were entitled to apply for a personal licence or anything else. Councillor Beasley mentioned public safety and talked about the experience of other licensed premises and that antisocial behaviour ebbs and flows. I confess that I'm really struggling to see how granting these premises a licence is going to put public safety at risk. I really do. Matters of fire safety, they're all dealt with under other legislation these days. In fact, the regulatory reform fire safety order says in terms that any condition that's attached to a premises licence that is relevant to matters of fire safety, basically, shall have no effect because it's all covered under their legislation and so on. A number of people in their written representations and elsewhere mentioned protecting children from harm. I have not seen one even suggestion of something that the grant of this licence might put children at risk. It's just sort of thrown in there for good measure and so on and so forth. And public nuisance, including noise and disturbance, an additional licence premises will add to that, including exiting the premises. Can I point you to the conditions? And this will be on page 41 of your agenda bundle. Under the prevention of public nuisance. The external area should not be used for drinking after 2100 hours daily, and thereafter a maximum of 10 persons will be allowed to smoke in that area at any one time. Reading that today, I confess to a tiny little error on my part. What I meant was you can't have more than 10 people out there, be they smoking or not. And it may well be, and it's a matter entirely for you, that you change that so that it reads as it was certainly intended. A maximum of 10 persons would be allowed in that area at any one time to smoke or otherwise, which solves the problem of, where you've got 10 smokers and then 49 other people. That wasn't the intention. The outside area has to be monitored by staff. How they actually do that is down to them. You don't prescribe in the operating schedule how you actually do it, which member of staff is going to go and so on and so forth. But this business about exiting the premises, we thought about that, and we specifically said that the premises will adhere to a written dispersal policy ensuring that all customers do not loiter in the immediate vicinity of the premises. With respect, I can't stop them loitering 50 yards down the road. No licensee can do that. They don't have jurisdiction away from the immediate vicinity of the premises.
About 5 yards down the road.
That is in the immediate vicinity of the premises, without
Excuse
a shadow
me,
of doubt.
Sorry.
Through the chair, and there's no cross-examination.
But there is a requirement for a written dispersal policy, and that has to be made available to both the police and the licensing authority on request. And if they're not happy with it, then all they do is they threaten a review of the licence, and it gets looked at and it gets changed and so on and so forth. But things like that, the way in which the dispersal policy is written rather depends on the sort of event that you've got. So if you've got somebody doing a yoga class, you're not going to have conditions or a dispersal policy says that I've got half a dozen door supervisors to see them off the premises at 3 o'clock in the afternoon when they've finished. It has to be flexible. Sorry, I didn't mean that as a pun. It has to be adaptable to the particular goings-on at any given time. So, things like that have been considered and they have been included within the application and so on. Just to answer a couple of questions, the condition that environmental health wanted about keeping the doors shut, how do you do that, we're asked? Well, the starting point is you have self-closers on them. You don't allow anybody to wedge them open. There are no hooks or anything like that. You open the door, it closes, just like that one does. And of course, there are staff there. And if people are coming to an event, it's not as if it's going to be a bar where people are arriving, coming, going all of the time. That's not in the nature of the place. They'll come here for a specific purpose because it is not a watering hole. It can't be. That simply would not work as a bar here. There is a bar here, but to operate it as a pub simply won't work. It's perfectly obvious from the nature of the premises, from the layout of it, and so on and so forth. And then previous issues, we've been told, we've got photographs of this, we've got CCTV of this, and we've got witnesses to this and that and so on. And despite ending up with an agenda pack that's the best part of, I'm going to get corrected on this one as well, but the best part of 100 pages long, none of that evidence, so-called, has been produced. And you were entirely right, sir, your colleague, when you questioned, well, how do we know it was from there? Well, if you got photographs, if you got CCTV showing it, that might have been a bit of a clincher. So why has it not been produced? I don't know. And then I'm criticised. I'm compared to Thompson's holiday brochures. Thompson's suffered a rather untimely end of late, and I hope the same fate does not befall me. But in all seriousness, the way in which I deal with these things, and I'm not giving evidence here, if you've got 3 or 4 people who have issues and are making representations with regard to a licensing application, it is a practical proposition to contact them and to talk to them about it, although because in this day and age one is always at risk of getting accused of bullying or intimidation or whatever, any such communication always goes via the ladies sitting there and their colleagues. I don't get in touch with anybody direct unless they specifically invite me to. Once you get to more than half a dozen people, it is not a practical proposition to try and have a dialogue with all of those people separately. So what we do is we say, here you go, this is what we have to say about it, all done and sent out way before Christmas, partly because I was on holiday, but also to give everybody the opportunity of saying, look, this is what we have got to say. Even the site notice that we put up, I always give my email address, my direct dial address, and say to anybody, if you want a copy of the application, if you want a copy of the plans, it's me. Ring me, contact me, and I'll talk to you. But it's a little bit unfair to criticise on the basis that we haven't had that dialogue when we have tried to do our best and made it clear that we're happy to talk to anybody and everybody. I could go on, but you seem to have addressed a number of things as we've gone along, and I think you've got the point. The issue is really one of whether we tick the boxes, satisfy the test within the existing policy, subject, of course, to the policy that overrides it, which is the national policy, which basically says you need to have some evidence to support what you're saying. And we're hearing conflicting things. We're hearing from Councillor Beasley, antisocial behaviour ebbs and flows. We're hearing from one of the other witnesses, or rather objector, representor, that, well, actually there isn't a problem of antisocial behaviour in this particular little bit. And we haven't had any evidence of crime levels or anything like that. Nor have we had evidence that, in actual fact, there is a pre-existing problem of late-night nuisance and so on, bearing in mind that this application, particularly for the sale of alcohol, does not extend into what is generally regarded as the late-night economy time, which basically starts at 11 p.m. So you're talking about a cumulative impact to an existing problem, yet we don't have any evidence of an existing problem, and indeed a couple of people have said, well, actually there isn't a problem of that at the moment. So that does all make it somewhat exceptional. The nature of the premises makes it exceptional. It clearly comes within the definition in the former Bournemouth Council policy, paragraph 1512. And for all of those reasons, I invite you to grant the licence as applied for. I do invite you to tweak the first condition and prevention of public nuisance on page, whatever it was, of your, it'll be page 30, yeah, that's the one.
On that point, Mr. Day, can I just ask one final question?
Yeah, of course you can.
What are the proposals of the applicant for the disposal of waste? What I'm getting at is, will the waste be left till the morning before it's removed, or is there a likelihood that it could be removed at 2300 hours?
There's no such thing as standard conditions, of course there aren't. I wouldn't have any difficulty, and I'm sure my clients wouldn't have any difficulty in saying, in agreeing a further condition that no refuse shall be placed or moved outside the building, because the premises is bigger than the building, between, say, 2200 hours and 0800 hours, between 10 o'clock at night and 8 o'clock in the morning.
Sorry, Mr. Day, just something for the committee to further consider.
It's usually environmental health to pick up on things like that, but they didn't do so on this occasion. They only wanted that one additional condition, which we're happy to mediate, and which, of course, you would need to include the one about the doors, and that, just to assist you, is set out on page 108 of the agenda papers. At all times, premises are open for licensed activities, either the door leading into or out from the premises, or the door between the entrance lobby and the function room itself, or both, will be kept closed, safe for normal access and egress. So unless I can assist you or your colleagues any further, that's the application. Sorry.
Thank you, Mr. Day. One more question from Councillor Barron.
Thank you, Chair. It's just out of interest, really. Obviously, it's HMO now, but previously it was a hotel. Presumably, it used to have a licence. That building, did it used to have a licence as a hotel?
Right. We're not aware.
It's a dual licence, actually. You can do both. Hotel or HMO.
Yeah, did it have a drink licence?
Oh, a drink licence. Yes, it did. Yeah, it did for years and years and years. Just before I bought it.
Yeah, but it certainly...
I can confirm it did have a... Yes, it had an on-licence for a hotel.
Yeah, but that's pre-2005.
The licence, I believe, was surrendered in...
It's a long time ago.
2008 or 2010, but it wasn't
it's over a
years
decade
prior
ago.
to that. Yeah.
Okay, right. In which case, no further...
Right, to the point of order, please. I'd like to attend the deliberations as an observer to enhance my own
gathering here.
So you mentioned that at the very beginning of the meeting.
I did, and unfortunately Councillor Farquhar wasn't here then. So he's obviously arrived between the start and where we are now. So do you have any objections for him to sit in?
No, of course not. Everybody has to learn. We have two other trainees here as well.
Thank you very
precisely
much.
for that purpose.
Thank you. We'll retire and come back to you as soon as possible. Ladies and gentlemen, firstly, can I say that the subcommittee want to make it clear that in consideration of this matter, they have only had regard to the 4 licensing objectives and not any other issues raised by any party this morning. Having heard from the applicant and representations from the ward councillor and local residents, both in person and in writing, and having regards to the statement of licensing policy, most notably paragraph 1512, and the statutory guidance, and the decision has been taken to depart from the cumulative impact policy due to the following exceptional reasons. 1. The size of the premises. 2. The proposed opening hours. 3. The proposed use as referred to by the applicant at today's hearing. 4. Noting no representations from any responsible authority, and in particular Dorset Police. 5. Noting the contents of the email from the Dorset Police dated the 27th of November 2019. And 6. Having regard to the proposed terms set out in the application. The subcommittee has decided to grant the application subject to further conditions as proposed. Those further conditions are, under the subheading, the prevention of public nuisance. 1. The external area should not be used for drinking after 2100 hours daily and thereafter, and a maximum of 10 persons will be allowed in that area at any one time to smoke or otherwise. 2. At all times the premises are open for licensable activities, either the door leading into or out from the premises, or the door between the entrance lobby and the function room itself, or both, will be kept closed, save for normal access and egress. 3. No refuse shall be placed or moved outside the premises between 2200 hours and 0800 hours. This has been a difficult decision for the subcommittee, and we hope that there will be no problems going forward. However, we would like to remind all parties that the licence could be subject to enforcement action should any problems occur. Thank you very much for your attendance this morning.
I can just set out the appeal process. There's an appeal to the Magistrates' Court, and that period starts 21 days from when the notice in writing is sent out.
Thank you. Moving on then to agenda item 6 on this morning's agenda.
So I'm currently instructed on items 6 and 7, so I'll wait here until I hear what you've had to say. And can I apologise on behalf of Mrs. Lovett? She had to go off for an appointment. Did not mean any discourtesy to you or your colleagues, and thank you for your decision.
Okay, moving on then to item 6, application for review of premises licence, Riviera Bar Restaurant, 560 Christchurch Road, Bournemouth. The subcommittee is asked to formally open and adjourn the above hearing until the 4th of February in order to comply with the requirements of the hearing regulations as agreed by the applicant and the police. Are members happy that we adjourn this item till the said date of the 4th of February? So praise. On a show of hands, all those in favour, thank you. That's unanimous. Item 7, review of premises licence Polski Sklep, 17 Lansdowne Road, Bournemouth. The subcommittee is asked to formally open and adjourn the above hearing until the 28th of January 2020 in order to comply with the requirements of the hearing regulations. Can I once again ask members, are they happy that the item 7 be formally adjourned until the 28th of January? Yeah. All those in favour, please show. Thank you. Unanimous. There being no further business to conduct this morning, I declare the meeting closed. Thank you.